Hi, this is Rahul Reddy. We're here live from Houston, Texas. We do bring in immigration news every week, Tuesday at 5 p.m. Central Time. You can post live questions on Facebook or YouTube. We'll try to respond as much as possible. Along with me is Emily Neumann. Emily?
Thanks for joining us today. And I've got my Astros gear on, day one of the World Series. Go Stros. So today we're going to be talking about USCIS H-1B denials. The percentage of denials, as we've been talking about for the last 2 years, just keeps going up and up and up and up. We have new data from the Administrative Appeals Office, but also what else can you do besides filing an appeal, such as filing a lawsuit, which more and more companies are doing these days. We also wanted to go over the new bill that was introduced, that's kind of the, I guess, opposing bill now to Senate Bill 386, the Fairness for High-Skilled Immigrants Act, and this is the Resolving Extended Limbo for Immigrant Employees and Families Act, the Relief Act. What does it entail? Are there any chances of it passing? We also want to update you. There was a press release put out today by the director of USCIS about all of the accomplishments at USCIS over the past 2 years, and there was actually a stakeholder call last week with USCIS regarding all of the changes they've made in customer service and how that's been going.
Emily, you're telling that from the past 2 years, the USCIS denials have been going up, RFEs have significantly raised up, denials are going up. What's the solution do you have? I mean, and you said you got stats from the Administrative Appeals Unit. What is the stats that you have? What is the best way of approach when you get a denial?
Yeah, so prior to this year, the most common way to overcome an H-1B denial was to file an appeal that goes to the Administrative Appeals Office. We had statistics that showed only about 3% of all appeals actually overturn the decision. So for quite some time, the Administrative Appeals Office was really just a rubber stamp approving whatever USCIS did in the case. Very few denials got overturned. That's actually been changing. Now about 15% of all H-1B appeals that are sent to the Administrative Appeals Office are being overturned or reversed. So that shows us that USCIS itself has kind of run off the rails, and the AAO, which is normally saying, yeah, you were right, you were good to deny this, is actually pushing back and saying, wait a second, you need to rethink this decision. But still, even with that slightly higher percent chance of success with the AAO, we are finding that filing a lawsuit is the best way to overcome an H-1B denial. You want to give us kind of an overview of that process?
One thing is that when you go to the Administrative Appeals Unit, it takes approximately around 1.5 to 2.5 years for you to get a decision. So if your H-1B is denied right now, and you're going to wait for 1.5 to 2 years, what visa status are you going to wait? You need to consider that. And 15% is a very less chance. If you by any chance are falling out of status, I mean you are not going to have any legal status, if you fall into the 85% of the chance, then you may be accruing the 10-year ban for you come back into the United States. So appeal might have some merits in some times, but most of the time it actually is not good, not practical at all. Because if you appeal it, 15% chance of approval, and that too you have to wait for 1.5 to 2.5 years, and sometimes even longer. That period of longer than 2.5 years period too. We advise people, though, I mean, instead of appealing it, it would be better to sue the USCIS. If you look into it, past how many denial percentages are there and how many denial percentages are right now, that shows clearly that this administration does not want to approve the cases. At this point of time, according to the USCIS statistics, 32% of the H-1Bs, and that is the same most probably stands with most of the other non-immigrant employment-based visas, the percentages have gone up very significantly on the denials. So if you look into the denial percentages for the previous administration right now, were there any change in the law? No, no change in the law. Was there any change in the regulations of the H-1B? None. Zip. The only regulation that I know about is the lottery changes, where master's degree will be considered first and then bachelor's degree, and now we have the regulatory changes with regards to how the lottery system, but nothing substantive to the H-1B. Nothing has been changed. The denials are occurring. Why? The reason being the administration has changed or interpreting the law quite differently than the previous administration. That definitely is a violation of the Administrative Practices Act. So if you're going to sue in the if you're going to sue the USCIS in the court, you have a good chance of getting those things overturned. We have seen significantly in our office, we are filing litigation against USCIS every single day on average. In the past 2 months, we are filing 5 cases on average. And we are getting good results on those things. And we are seeing the same thing also in the other law offices which are actually choosing to litigate. Emily, let's say, for example, if I get a denial on specialty occupation alone, what are the chances if I go to the appeals office? What are the chances if we go to the court? Now, can you explain what your arguments are in the court when you go, if you get a specialty occupation denial?
Yeah, I think that generally the chances of seeing a reversal in the court are much higher, possibly up to 70%, compared to the AAO, which is only 15%. And on top of that, you're going to get a decision most likely a lot faster, potentially within even 60 days of filing your lawsuit. The types of arguments that we're making in these specialty occupation denials is that the agency is acting in a clearly arbitrary and capricious manner when you have consistent documentation that they've approved the same person for the same job years and years, every 3 years, nothing has changed, yet we get a completely different result. That is the definition of arbitrary and capricious. So that is one situation where litigation can be helpful, especially where it's an extension or where the company has a long history of filing for that same type of job. How can it be a specialty occupation in one hand and not a specialty occupation on the other when it's the exact same job? Also, we're making the argument that the government is relying solely on the Occupational Outlook Handbook, which does have some educational discussions about what different occupations require from an education standpoint. But even the Department of Labor has come out and said that that occupational handbook should not be relied on for legal purposes, and it is meant to be for a career guide for new students, that are starting out in that occupation or wanting to go into that profession. It's not meant to be relied on for making determinations of specialty occupation.
And then for the specialty occupation, the law prescribes that you must meet one of the 4 requirements. But the USCIS is interpreting it's not one of the 4 requirements. You have to meet all 4 requirements. One of the requirements is that the position must require a specialty degree. The employer must require a specialty degree. The industry must require a specialty degree, or the totality of the circumstances must require a specific degree. Now, the way the USCIS is interpreting is that the employer's burden is to prove all 4 of them, but that's not what the regulations will say. Now, if we go to the court, we have good chance of approval. Now, according to the Bloomberg News, the chances, if you go against the USCIS on the regulatory agenda, the chances of approval is 85%. Now, Emily has been modest in telling 70% to keep her expectations a little bit better so that when we get the results. But now the stats, when we go to the courts against any of the regulatory interpretations, are very high in getting the approvals, not just for immigration but everything else. If you consider the 4 factors, the way they're denying the 4 factors, that we need to prove all 4 factors instead of only 1 factor, that itself is a good chance for us to get the approval in a specialty occupation. Now, Emily, with regards to the employee-employer relationship, when we are suing the USCIS, when we get the denial, they're asking for the end client letter, they're asking the contract between the end client and vendor letter, they're asking for the job description in the SOW, statement of work. I mean, these things are not there. Now, this job belongs to an employer. The employer is signing the I-129. The employer is signing the LCA, which states that he has a job for 3 years. And they're asking for the job for the end client. Why are they asking for the end client and denying the H-1B? I mean, isn't it that they're telling that the job actually should belong to the employer, not to the end client? Why are they asking these end client letters? And if there is any discrepancy in those things, they're denying the employer's end client letter. What is that you're doing in the court when you're getting a denial in an employer-employee relationship?
Yeah, we're really pointing out that the agency is going well beyond a preponderance of the evidence standard, and also they're requiring more than what the regulation says. The regulation says you can prove employer-employee relationship by showing you have the ability to hire, fire, pay, supervise, or you have the otherwise right to control. They're combining that all together and saying you have to show every single one of these things. And because the end client letter, or because you don't have the contract, we don't know whether you have the right to control. Well, that's not a requirement if you show that you have the ability to hire, fire, pay, and supervise. So they're really going beyond what the regulations require. Their memo that they're interpreting back from February,
February 22nd of 2018, and also Newfield memo in January of 2010.
Yeah, especially the most recent memo, it did not go through any kind of notice and comment period, and it really is not just a matter of interpreting the regulation. It's going beyond that, and so that memo itself we're attacking, that it was not lawfully put forward and should not be relied on by officers as well.
Emily, also, it's not just the denials right now. There are also short-term approvals that we're getting right now. The short-term approvals, when we are filing H-1B for 3 years, they're only giving for 6 months. We have seen cases only giving for 1 day, and sometimes they're giving approvals post-dated. In other words, we filed, let's say, in August, and then we got a result on October 20th, and they're only giving up till September 20th. I mean, this is ridiculous. This is going on. We are suing the USCIS because a couple of different reasons. Even though the employer has stated on the employer the I-129, the LCA, they are looking into the dates of the end client. They are looking into the dates of the SOW. Well, the job belongs to the employer, not to the end client. So they should be looking into the LCA and the H-1B petition. They should not be looking into those things to give it 3 years. The second thing is the job belongs to the employer, not to the end client. The main aspect, the legal aspect that we are attacking when we are suing the USCIS is when we are applying for 3 years H-1B, or in some cases 2.5 years, depending on the 6 years maxing out, they are giving a short-term approval. They are not giving any explanation whatsoever at all. Now, the explanation that you might be getting, that the SOW doesn't have up to 3 years, the end client doesn't have up to 3 years, is an explanation given by your lawyer, not by the USCIS. When the USCIS is giving a short-term approvals, according to the Administrative Practices Act, they are supposed to give you a written explanation why they are giving a short-term approval. It's a complete violation of Administrative Practices Act. We haven't yet got any response from the USCIS when we are suing. They're just reopening and approving it for the period that we approved. We're not seeing the court to explain them, look how dumb the USCIS is, because they're approving those cases. I mean, it's easy victory if there is a short-term approval. You may want to go to the court rather than keep on filing like every 3 months, every 6 months, you have to do that. And what we also noticed is that if you sue the USCIS, for the company, next time when they want to deny a case, they'll be looking into very careful if they want to deny or if they want to give a short-term approvals. Emily, a lot of people are in the presumption that when you sue the USCIS, there will be a retaliatory action. They will come with guns to your home and shoot you down. I mean, this is the kind of impression some of the people come in. Some of the people might be coming from the totalitarian countries, and some of the people coming from the kingdoms. Mm-hmm. Is that true in the democratic system that we have here?
No, it's not. I mean, it's within your legal right to sue the government, especially under the Administrative Procedures Act. It gives you the power to do that. And by using that power and taking the government to court when they're not doing their job, there's nothing that allows the government to retaliate against you after that. It's not something that happens here. I think people are worried that, well, I've got my green card pending and I'm over here suing USCIS for an H-4 EAD delay or for my denied H-1B. Are they later going to deny my green card because I sued them 5 years ago? And the answer is no. You are within your legal right to sue the government in order to get what they're supposed to be doing, and they can't deny your green card because you sued them. They have to have a lawful reason for denying your green card, and there's no discretion really involved in that. So and other thing to realize, although employers and employment-based immigration, we really have only talked about litigation as an option very recently because we've never really had this problem.
Well, we were getting all approvals, so there was no need.
Right, everything was being processed timely, we were getting approvals, there was no need to sue the government. But in other areas of immigration, the idea of suing the government has been around for years, forever, and people have been successfully using those avenues. Back in the day, when an N-400, a citizenship application, seemed to get stuck in security check forever, at some point, USCIS has to complete the process. The Administrative Procedures Act says you have to complete the application within a reasonable period of time. So if you can show that their delay is unreasonable, you can sue to force them to complete the application. And that's been going on for years. There's nothing new with that. It's just, I think people are not used to the idea, especially in employment-based immigration, but there's certainly no downside.
And then also when your employers or when you're fearful about this one, here is what Administrative Practices Act says that when you're suing the government, let's say your company is suing the government on H-1B denial, the Administrative Practices Act only allows discovery or to have review of the file, only that particular file for which the company has sued. They cannot open any other files that are not related to that. Let's say, for example, if you're filing H-1B for one denial, can they say that can the employer give information about all the H-1Bs, all the end client letters, all the vendor letters? No. The Administrative Practices Act does not allow the USCIS to open up anything else other than the file for which you sued the USCIS. So please have this one notified to your company. If you get a denial, have your company contact us or any of the litigation lawyers. With 32% denial ratings, if you're going to be like this, every 6 months you're going to keep in renewal. In 18 months or 24 months, you'll be out of this country. Even though you're legally allowed to work in this country, the law allows you to work in this country, the administration is misinterpreting the law and is completely changing the law without going to the Parliament. Emily, on this Senate 2603 bill, the resolving extended limbo for immigrant employees presented by Senator Durbin, is this a real bill Senator Durbin wants to pass, or is it just like diverting the attention of the people, though?
Yeah, it is a real bill. It sounds great. It's got everything we want in it, but it just has no chance. In the current environment with the Trump administration, even if you somehow miraculously get this bill through the Senate, get it through the House, you come up with your compromise and pass it, there is just no way I see that getting signed into law.
This president is not going to sign this bill. This bill was formed, a similar kind of this bill was passed in Senate with 68 votes, if I recall, back in Gang of 8 when Senator McCain was there. It was the Utah senators and the senators from Arizona, plus the Senator Durbin was also part of the bill. It passed through the Senate, but it never hit the floor of the House at the Obama administration. But at this time, Senator Durbin is just trying to shy away from having the Senate 386 bill passed. If the Senate 386 bill, which even though has some amendments from the HR 1044 bill, this bill, the Senate 386 bill, has a good chance of going through everything rather than the bill presented by Senator Durbin called 2603. We are not speaking that this bill should not be passed. It has very good things. I think so. It has all good things. It has all good things which are there in the Senate 386 bill and probably more good things. But the practicality you need to look into, the political atmosphere that you need to look into in the Washington, D.C., At this point of time, I would recommend people, those who are getting backlogged, don't get sidetracked with this one. Keep pressure on the Senate 386 bill, Senate 386 and HR 10044, and keep a put pressure on that. Don't get diverted in it. The bills, the law that as it exists is completely discriminating those people, some of the people in there. So Senate 386 bill is actually taking the discrimination off. When you guys speak with the senator, when you guys speak with the congressman, don't tell that Senate 386 bill or the HR 1044 is favoring your particular country where you're born in. It's not favoring. It is treating everybody equally. So please, when you speak to the media, when you speak in the press, when you make some comments on the YouTube and other things, don't tell that the Senate 386 bill is actually favoring in a particular country. No, it's not favoring. It is treating everybody equal. We don't want anybody to treat people higher than they normally are. The Senate 386 bill really addresses it. It has a practical chance of going through, and if Senator Durbin has an objection, it still can be passed through. I mean, if this bill can be put into vote, I think so it has enough votes to pass through the Senate. So you may want to put a pressure on the Senator Mitch McConnell, who is the Senate Majority Leader, to present this bill, have the discussion, debate, vote up or down. That would be the best chance. If Senator Durbin is not going to give up on that, put the bill out there. Let's see who is going to vote for it, who's not going to vote for it. I think so it has good chance because it passed through more than 2/3 of the majority in the House. It has good chance. It only need to be passed by 60 votes in Senate, if at all, if there is some objection that comes in, only by 60 votes out of the 100 votes. So we have the votes, I think so. I absolutely think so we have the votes. So put a pressure not just on Senator Durbin, but also put a pressure on Senator McConnell, because he's the one who's going to bring it to the floor.
All right. So earlier today, we had the USCIS acting director putting out, well, I guess this was last week it was released. Cuccinelli announces USCIS fiscal year 2019 accomplishments. And, every single accomplishment in here is really more talking about just increasing red tape, especially for employment-based immigration. We've got all this public charge. We've got difficulties with customer service.
Fingerprint.
The fingerprinting.
New fingerprint. Now, today they announced a DNA. Hopefully they won't implement it on the non-immigrant visa people. They definitely are implementing on the migrant people, but hopefully not on the non-immigrant visa people. So what is he telling, Emily? Are you telling that he's going to cut down the timings?
Oh, definitely not. I think it's pretty clear that his plan is to continue more red tape. It's all in the idea of protecting American workers, but really it is meant to limit high-skilled immigration.
Yeah, and delays are going to continue to occur. You may want to contact, because if you are going to go in the normal path, it's not going to happen. We ourselves have never sued USCIS, even though we're in existence for more than 21 years, until about June of 2019, which is just about 4 months from now onwards. We never sued USCIS in federal court, never. But we have taken a different stance right now, because we're completely about a third of our revenue or more of that is coming from the litigation. We have choose to take in this path because we have no options when we see our customers getting denied, irrespective of what kind of documentation you provide, or they're asking for impractical documents. You have to sue the USCIS. If it's a delayed and you're having some problem with the delay, you may want to consider suing the USCIS. You may want to contact us or any lawyer that is willing to sue. If they're not going to willing to sue the USCIS, you're going to get the denial or delayed for a long period of time. Emily, the stakeholders call for the USCIS, where they allow people to come in, voice their opinion, and you were in the stakeholders call. What did they say on that?
Yeah, so this was a call where the government is asking, what do you think about our new customer service model for when you call the 1-800 useless number? And, out of every single person that was able to give a comment publicly on this line, not one of them was favorable to USCIS or happy about the current state of customer service, if you can call it customer service. They talked about the InfoMod program, which is their plan to modernize the InfoPass system. Basically, that means get rid of InfoPass. I mean, before, you could go online to the USCIS website and schedule an appointment at your local office and go in and talk to a live person face-to-face about your case. You could get assistance with delayed EAD cards. You could get an interim EAD card. You could get a travel stamp in your passport if you hadn't received your green card yet. You could ask them what's going on with your case. All kinds of things you could do by talking to a live person in your city. All of that is gone, and now they want everyone to go through the e-request process, which is not bad. I'll say it kind of works. But the calling the customer service, oh my goodness, you wait on hold for 30 minutes to talk to a contractor who can give you no information about your case other than what it says online. Obviously, I already checked online. I don't need to be told this. And then after getting all of your information, going through everything, what's the reason for your call, and then verifying your name, verifying your address and your date of birth and what kind of application you filed, finally, when you get to the point, they say, oh, I need to transfer you to a level 2 officer. Great. Except that, oh, I'm sorry, we just turned off that because we got too many calls today. Try again tomorrow. That's happened to me. I can't tell you how many times. And on top of all that, for attorneys, they won't talk to our paralegals. So I have to schedule out a block of time in my day to be available for when I finally can get on the phone with someone and then try to get my call transferred, and then sometimes get a call back at 8 o'clock at night. It's just a mess, and everyone was complaining about it. It doesn't seem like they have any plans to improve it. For anyone who had a complaint or a negative comment, they just said, please submit a request for liaison assistance through the Ombudsman Office, which the Ombudsman Office takes 5 to 6 weeks to get back to you and has not been helpful in my experience. So don't expect much when you're calling customer service. And do remember, though, that if you're calling about an I-129 petition, like your H-1B or your L-1 or something like that, you can't call. Only the employer or the attorney can call. So even if you do try to call, you'll go through all of that mess for them to just send you an email later that says you're not the petitioner or the attorney of record, therefore we can't give you any information.
A question, so I want to take it, Facebook question from Barney. How much time does it take for the, how much does it cost to have the litigation filed for a denial? It is reasonably costly. It's in a reasonable within your range, Bernie. We have noticed we have cut down the cost for it because we have increased the volume of the litigation. That's the only way that we are able to get these litigations out. We have decreased the cost, but you will have to contact us privately to check what's the cost involved. First, we will look into the denial to see if or not you're eligible for the litigation. There are sometimes it may not be worth for you to litigate the case, and we will let you know whether you're good for litigation or not. Question from YouTube from Dan. I'm a green card holder. Can I sponsor for my parents and my siblings? No, for the green card purposes, you cannot sponsor for your siblings and for your parents if you are a green card holder. Only U.S. citizens can sponsor for the parents or siblings. For parents, it's an immediate relative, so there's no waiting period. For siblings, the waiting period will, depending on which country you are from, anywhere between 12 years to approximately 25 years.
Amrit from YouTube has a question about TN visas and wants to know if a Canadian citizen can qualify for the TN if they have an approved I-140. There is a big risk of denial here. Now, the TN, you have two ways to apply for it. You can apply when you're traveling into the United States at the port of entry, or you can apply with USCIS if you're already in the U.S. and apply for a change of status. At either of those times, either USCIS or CBP is going to make a determination about whether your intention of coming to the U.S. is truly temporary. Having that approved I-140 kind of says otherwise. It says you have immigrant intent. There is a chance that you could be denied entry at the port of entry, or your change of status could be denied. I think that, potentially if your priority date is nowhere near being current, you may have the opportunity to explain that on this particular trip coming in, there's no way I can obtain a green card, and that I'm just coming here temporarily this time, but it is going to be up to your ability to convince the officer of that. Definitely a risk there.
Lalit has this question that comes very commonly, is that his I-140 is approved more than 180 days ago. Can he get unlimited H-1B, 3 years H-1B with different companies? The answer to your question, Lalit, is clearly yes, you can. You can. Even if once you move out of the company, if previous company withdraws, it will not have any effect whatsoever at all in you keeping getting the H-1B extensions perpetually. Another question that comes from Divya from Facebook, it's a very tough question, is how many years wait time it is for the EB2 India category? Divya, if you're applying for the green card right now, assuming that things will go in the normal phase though, you will not get the green card. I mean, you have a good chances of, sorry, but dying before you get the green card, because the numbers that are there right now, it's going to take about 150 years. When we wrote an article, Emily and I wrote an article, for 108 years it takes in February of 2018, people laughed at us and said, that much long time. Then another institution called Cato Institution, with me and Emily, we value that institution very much, but they proved us wrong by 42 years. They said 108 years is wrong. It's 150 years for Indians to get the green card. So, we respect that organization, but they have a little bit more better statistics than what we have. So unless there is a change in the legislation, the I-140 is only to extend your H-1B and not actually to get a green card if you're from India.
Anam from Facebook has a question. The green card interview took place more than 4 months ago and still no decision. Is there any inquiry that can be done? Is this normal? Well, assuming that your priority date has remained current since the time of your green card interview, I'd say no, it's not normal. Inquiries are going to lead you nowhere. I would suggest considering litigation. I know we talk about it a lot, but you can file a lawsuit for a delay in a pending 485, and I think that might be the next step for you.
Keep on traveling is his question. His priority date is August 2010 priority date EB2. How many more years of wait period? Oh, it touched all the way to May of 2010. You missed by about 4 months. But based on the research that I've done in February of 2018, it might take around 8 to 10 years from that time. So for your priority date to become current, unless there is some changes in there, in the legislation, or some extra phased green cards that comes out from EB1 and EB2, but it looks like EB1 is completely filled out, EB2 is completely filled out by other countries. So it may take up to, from 2018 onwards, anywhere between 6 to 8 years for you, or 6 to 10 years for your priority date to become current.
Tushar from Facebook has H-1B and is going for stamping in December. He has health insurance from his company, but his wife is currently outside the U.S. and applying for the H-4. He wants to know if she needs to have health insurance to apply for the H-4. This actually relates to the presidential proclamation that came out a week and a half, 2 weeks ago, where the president issued an executive order basically stating that certain people applying at the consulate need to prove that they have health insurance or will receive it within 30 days of entry. As of this moment, that only applies to those applying for immigrant visas, the green card. So for your wife to obtain an H-4, it is not necessary for you to demonstrate to the consulate that she has health insurance at this time.
Emily, there are about at least 8 or 10 questions on the Senate 386 bill. I may need your attention on it. What are the chances for this one to be approved, and what do people need to do to get this one approved from their viewpoint? I mean, they're not senators, they're not congressmen. What do they need to do?
I think one thing that would be great right now is sharing your story about how the delay is impacting you, how it's impacting your kids. There was a really good article yesterday, I believe, about the idea of H-4 kids who've practically lived their whole life here, aging out and having to leave to go home or convert to F1 status because there's just no chance of them getting the green card with their parents. And I think no one intended for that to happen when they created these caps and when they created the per country limit and all of that. So bringing, if you can share your story, do an op-ed, share it on social media, that helps. Writing a letter to your senator, also to Senator Durbin, to Senator McConnell. I mean, we may have to get away from the idea of unanimous consent if we can't convince Senator Durbin. And so we need to push Mitch McConnell to bring it to the floor. And we do have a sample letter on immigrationgirl.com that you can use that template. Make sure that you include information about your personal story. Again, share how it's impacting you personally, how it's impacting your ability, your career, your kids, your family, all of that is going to be very helpful in getting this moving.
George has this question from YouTube. He's born in Kuwait. He's starting his green card process. How is the rest of the world queue? Is it still fast? Yeah, it is still fast. Since you're born in Kuwait, even if you're not a Kuwaiti national, you may be able to use you should be able to use the rest of the world category at this point of time. So yes, it's way faster than compared to the Indian nationals or the Chinese nationals who are born in their respective countries.
Tiru from Facebook has a very common situation. He recently changed status from F1 to H1, but spouse and kids H4 did not get filed. So he wants to know what options they have. So since your change of status took effect on October 1st, and I'm assuming they were in F2, that means they went out of F2 status on October 1st. It is now October 22nd. Now, typically, when you file a change of status for anyone, you always have to prove that on the day of filing, you are properly maintaining the last status you were given. So in their situation, they can't prove that because they're no longer in F2 status. That being said, we find usually USCIS is willing to overlook a slight delay in filing the change of status from F2 to H4 in this exact situation where it was an oversight and not done on purpose and you caught it quickly. So if you can get it filed relatively soon, there's a good chance that they can get the change of status in the US. It's going to take a long time. Processing times are horrible for the I-539. So if you are nervous about it and don't want to wait 6, 8, 10 months for an answer on that, the other option would be to have them leave and apply for H4 stamps at the consulate. This short period of out of status that was unintentional should not have any impact on their ability to get the H4 visa stamp.
DJ has this question from YouTube. His I-140 has been approved for less than 180 days. Can he switch jobs? Can he still retain the priority date? You can switch the jobs, but however, if the I-140 has been withdrawn before 180 days, then you will not be able to use the priority date to another company when you join another company. So the crucial point here is that whether or not the company withdraws the I-140, you'll be completely at the mercy and how your company is going to do on your I-140. So I would recommend to avoid that, but if you can't, I mean, it depends on whether or not the company withdraws the I-140 within 180 days. If it doesn't withdraw it, even though you left the company within 180 days, you can use that priority date so that to port on to the next companies.
Let's see here. Akilanan has an interesting situation. His H-1B approval came with his manager's name in the petitioner section instead of the company name. What needs to be done? Will it impact visa stamping? So assuming this is a USCIS error, typically if it's premium processing, the employer or their attorney can send an email to the premium processing unit to ask for a correction. The next step, if it's not premium processing, would be to contact customer service to request a correction. If that doesn't happen quickly enough, they could file an I-129 amendment to correct the name on the petition. I think whether it impacts stamping, it's probably pretty unlikely to impact stamping, but I would have your letter have your employer provide a letter to you to carry to your visa interview to explain the situation and that it was just a typo on the approval.
Jagyash from Facebook has this question. His salary is less than what is being prescribed in the LCA. What should he answer? If your actual salary is less than the wages that are prescribed in the LCA, you should not go for the interview at all. Yeah. You should withdraw your application and then file another H-1B to come back. I would not recommend that you approach and get the denial. I would recommend that even though it's today, I'm assuming that you are in India right now, withdraw the application, don't go for the interview, file another application. Get an H-1B amended or try to get another job. Don't go for the interview because you're misrepresenting there, because I wouldn't advise you to go for the interview at all.
Indu Shaker from YouTube has a question that comes up quite a bit. So he's already got his H-1B approval that's valid until next August, but doesn't have the visa stamp, and is planning on filing his H-1B extension early, which is great. We recommend that in premium processing. So he's going to be getting his H-1B extension very early, way before the current petition expires, and he wants to know, can he go for stamping before the new petition takes effect? And the answer is yes, you can. You can show your current approval notice and your new approval notice, and you should be able to get a visa stamp that covers the whole time all the way to the end of your second approval notice.
Smriti has this question. She went to visa interview in 2014. She got a 221G. Now she's planning to go for stamping in December. What are the chances of 221G again? Smriti, one thing is that what it all depends on the situation though. Now I don't want to give the answer, it all depends on the situation, but when I would recommend that before you go for the interview, speak with a lawyer. If you were to contact our office, we would recommend Rebecca Chen in our office. She's very good in these things. What she does is that she takes the entire application, she reviews the entire profile, she looks into your social profile, she looks into social media profile. She interviews you just like a consular officer, like a mock interview to see how you stand at. What we noticed is that most of the denials could be easily avoided. Most of the 221Gs can be easily avoided if the employee is well prepared with the application. When you're spending so much money on it and there's a lot of salary involved in it, if you don't get into this country, it's worth spending a consultation with a lawyer who goes to the mock interview. It's important. Most of the people are not even aware who their employer is. When we ask, let's say for example, you're working with ABC consulting company and your employer is, let's say, Pepsi. When they ask, whom are you employed with? They say, we're employed with Pepsi. Well, that doesn't have the H-1B approval. We're going to deny your H-1B. It's very simple, certain things that you need to be careful about. We strongly recommend that you go to the mock interview before you go there, and that it may avoid. It's not that it's going to be completely, you're never going to get the denial, you're never going to get a 221G, but you're going to at least avoid the mistakes that you're going to be doing.
Raj from YouTube has recently received his H-1 extension approval, but his current visa stamping is still valid until January 2020. And he wants to know, if he travels out using the existing visa stamp, what kind of I-94 will he get when he returns? So you can use the existing visa stamp. It remains valid all the way through January 2020. So as long as you enter before that date, you can show your new approval notice to the officer at the port of entry, and you should be granted an I-94 that covers all the way till the end of your approval notice, not just your visa stamp. However, there are a lot of mistakes that happen in this. So if you need to check what they put in your passport before you walk away and make sure that they give you the full end date that you're authorized for. If they give you the shortened date till January 2020 and you leave, it's a little bit harder to get that corrected. You either have to go to deferred inspection or possibly even file an extension again or travel again in order to get it corrected.
Emily, Anand has this tough legal question on the YouTube. Can a H-1B person contribute to the political campaign? Can they raise the money? can they raise awareness, hire the people to raise the awareness regarding the Senate 386?
Well, I don't think they can contribute to a political campaign, but they can certainly form a group and raise awareness for any, legal purpose that they want to.
Anand, let's say that we are immigration lawyers. We'll try to shy away whether or not you can give the political contributions. We could clearly say that you can have groups of people, families together without contributing any money. You can raise awareness. You can have everybody write letters to the senators, to write letters to the press, write letters to different people, try to tell your stories, contact the senator's office, and then if you need any guidance, you can always include me. I can give you some guidance, but as far as the political contribution is concerned, we would like to shy away in answering because I would rather have some political lawyers to answer that question though.
Sridhar from YouTube has a very common situation dealing with the name. His name's listed one way on the passport, it's a different way on the I-797 approval notice, and now on the labor certification it's in even a different way. And wants to know if it's going to be a problem for the green card. Well, as far as the name being different on the labor certification, I've never had any issues with that. They're not really looking at that at the labor or I-140 stage. At the 485 stage, that's where they're going to be verifying your identity and doing fingerprinting and all of that. So if the name is different on the labor, never had an issue. General rule of thumb I follow is whatever is on the passport, that's what I use to fill out any form, whether it's immigration, whether it's driver's license, whether it's Social Security, I-94.
I have an objection to that. That's what I did too, but it's different when it comes to, I got messed up with my name. My family name is Rahul, my actual name is different. So what happened, I filled it as it is, as in the passport assembly, and I got messed up completely. I'm living with a different name than what I am. As such, as the answers to the question, Emily, though, one easy thing that I would tell him to do is that go to the name change, simple thing. Go to the court, local lawyer, pay $500 or $1,000. They'll give you a name change. It's so simple. They'll give you the name change. And then in that way, then you can change everything at one point of time, and then you have a perfect name. I did a mistake. I'm living with the name. That's not mine. Rahul is not my name. That's my family name. But we haven't seen any problem in getting the green card. Have you? No, I've never seen any. And previously, when I got a green card, there were not good evidences, whether it's you or not. Now they have like everything in biometrics, everything in fingerprinting. So you have good evidence that you are the person that actually are. So we haven't seen much problems but we have seen more problems in getting the driving licenses and other issues though.
Vijay Prakash from YouTube wants to know if I can file a lawsuit if my green card EAD is not getting approved within the processing times listed on the USCIS website. Absolutely. You don't even have to wait for the processing time on the USCIS website.
Emily, why do they don't have to wait for the processing times to sue the USCIS?
Well, when you are filing the green card EAD, the only thing you have to prove to qualify for that EAD is that you have a 485 pending, which you filed together. There's no thought process involved in it. There's no, looking into your qualifications or anything like that. It's practically automatic. So
are you telling they will fit into the congressional theory of 30 days approval?
Right, exactly.
So when you're suing the USCIS and the EAD, you're not going with the 5.5 months. You're actually going with the 30-day rule.
Mm-hmm. Right, and so if you're filed your EAD 30 days ago and it's still pending, you can absolutely
Is that considered as expedited process? No.
No.
It's not considered expedited process. The Parliament expected the administration to adjudicate these things in 30 days. You don't have to go by the USCIS online system. They are actually violating the law. By approving it, there is nobody to question it. You question it, they're going to adjudicate the application faster, that's all. And if you want to, you can join our litigation that we do very frequently, you can join our litigation group that we do every other week on that.
Question from Facebook. Gautam wants to know, his H-1B petition was picked this year in the lottery. Congrats. It's been transferred to a different office back in September, and he wants to know how long should he wait for a response from USCIS? Well, there is no real processing time. I mean, we had petitions last year that were still pending in January, February, March of this year. There's no requirement for them to process them within a certain amount of time. So the best thing you can do is upgrade to premium.
Amrit has this question from YouTube, and he has a very genuine question, Emily, that I had a discussion with Jonathan Waston last week on. Can we file a litigation on reclaiming the unused green cards? Amrit, we have considered that very seriously. We had discussed it with our Washington, D.C. lawyer, Jonathan Waston. I had an extensive meeting last week, and we discussed it, and we discussed about the crowdfunding, and we have less chances of success in getting this one adjudicated. I have to admit in front of the YouTube and Facebook, we have less chances of getting the approval, getting our work done in getting the unused green card. Amrit is speaking about the unused green cards between 1992 to 2003. There are about 400 to 600,000 green cards, approximately 400,000 green cards that have been wasted out because back in old days, the wasted green cards were not being given to the overused countries. That's the one he's speaking about. I discussed with Jonathan. Jonathan used to work with USCIS before. I discussed with Brad, who's also a lawyer in Washington, D.C. I discussed with him. Both of them were very not that positive in getting these things. Now, raising the funds raising the funds in the litigation, the crowd looks to be easy for us. We could raise it, but we need to give a reasonable certainty of what the chances of it. One thing we can do is that if we litigate this case, though, it's going to be a lengthy litigation. It's not going to be a short litigation. It might take years for us to get any positive result from us. One thing is for sure, if we file the litigation, is that we're going to get into deep. We're going to go to discoveries. We're going to find out what exactly the USCIS is doing behind the doors in doing all these adjudications. We might get a lot of information from USCIS to dig in and find out what they are doing in their applications. We might be very successful in that. We may or may not be successful in reclaiming it, but we will investigate more thoroughly on litigating on that matter too.
All right. Barani from Facebook wants to know, his spouse has never had an H-1B before, but she has an H-4 EAD. Can her employer file an I-140 on her behalf? Absolutely. There's no requirement that you be in H-1B status to be sponsored for the green card by your employer. Her employer can file a labor certification and I-140 on her behalf while she's in H-4 EAD. Another question from YouTube from Rajesh. Bad situation here. His wife's H-4 EAD finally got approved after 5.5 months, but the post office misdelivered it. And they agreed that it was their mistake, but he wants to know what the options are. My experience with USCIS has been, if the card has not been returned back to USCIS, they're not going to assume that they did anything wrong, and they're going to make you file another I-765 application to replace the lost card. If it was returned back to USCIS, then you can have the process, go through the process of having it redelivered to the correct address. I'll caution you on both of those. When we've had people that it did get returned back to USCIS and they said they would resend it, we've waited months and called and followed up, and USCIS says we have a backlog of EAD cards that were misdelivered and we need to return them, and it takes 6 months to get them to redeliver your EAD. It's ridiculous. So you may want to consider refiling. That might be faster, and then in 30 days file a lawsuit. I hate to say that, But you're going to be dealing with this hassle for some time. Hopefully that's not what's happened here. Hopefully yours will not be that difficult, but just prepare yourself. This might not be a fast process to fix.
Vijay Prakash has this question. Did I had a chance meeting with Senator Durbin in Chicago? I tried to get an appointment, couldn't get an appointment. I did meet with the community leaders there that were involved in the rally that they have conducted. I have been in touch with them before the rally and after the rally, and I have given some good advice to them. One of the major advice that I would give it to them is that don't give the leadership to somebody else. I told them well in advance that everybody is going to claim that their organization did the rally, and that exactly happened. There are 10 different organizations that have actually not contributed in getting the people that all claim that they actually did the rally, which while it was actually the affected people who were there in the rally, the people who have been waiting in line for the green card who did the rally, and then you have 10 leaders. It's like this: if there is a successful person, there are 100 dads, and if a failure person has none. Since the rally was success, there are 10 dads coming in saying, well, he's my son. And that's what happened there, and I advised them well in advance. I did meet with them, and these leaders these people who are affected, they're very good, they're well organized. We are expecting that they're going to put the pressure. We have advised them, we have given the drafts of the letter. We told them not to be satisfied just by calling or doing an online thing with the White House petition. You need to write a letter. If necessary, go and meet with the Senator Durbin's office, though. But I did not have a chance. I couldn't get an appointment with Senator Durbin to meet the last weekend when I was there.
Ron from YouTube has a question about his H-1B extension. So his was expiring in February of this year, but he filed an H-1B extension in January before it expired. He wants to know if he can stay in the U.S. until that extension is approved or denied. Yes, once you've timely and properly file an H-1B extension, as long as it's filed before your previous status expired, you're in a period of authorized stay even after your current petition expires, and you can remain in the U.S. until you get a decision on that extension.
One question from Manasi is a good question. Can one file a lawsuit for EB1, EB1A, I-140 application that has been pending for more than 9 months? Yes, you can, but EB1A has a premium processing. Why not do premium processing? Manasi, if you're speaking of EB1C, EB1C doesn't have a premium processing. EB1A has a premium processing. If you go through us, we're going to charge you more money than $1,400. I assure you, I don't know who other lawyer is going to take you under $1,400. And it's an easy way for you to get is file in premium processing. Yes, under EB1C though, I-140, there is no premium processing. They're taking even 2 years to adjudicate the EB1C applications. That point of time, I would strongly recommend that they can litigate. Though in the EB1 cases though, it's not 30 days that we have to wait. We have to wait for 60 days. We have to wait for 180 days before we go for litigation. It's for the I-140s, it comes under immigration applications, so they can take 6 months to adjudicate the applications before. So you can litigate only after 6 months.
Viv from Facebook has a very common question that comes up. Looking at the CBP website, after you enter, you receive your I-94 online, and then you file an extension of your H-1B, for example, and you get that approved. And now you file a transfer, and you get your transfer approved. But the I-94 never gets updated online. Is that going to be a problem? No, the online I-94 is only updated when you travel. When you're in the U.S. and you file an extension or a transfer, your I-797 approval notice, assuming you received the extension of stay, will come with a new I-94 on it. The number should remain the same, but it'll give you a new end date. It's a little card at the bottom right-hand corner of that I-797 approval notice. So even though your online I-94 is still the old date, if you've gotten your approval notice, that's your new I-94, that's your new end date.
Question from Rahul Reddy Jetty from Facebook. He has filed a H-1B extension before the I-94 expires, which is February of 2009.
I think I already answered that one.
You already
Yep.
covered it, sorry.
Let's see if we can get any more. One last question here. Harish from YouTube wants to know, should I stick with my current I-140 and wait for years to get a green card, or choose a dependent work permit in Canada and try for permanent residence in Canada?
Let me answer that, Emily. If I were you, I would go for Canadian green card. I come from, Indian background. I've been an immigrant. I would take the option of going to Canada and getting a green card instead of struggling and watching these videos every week. I would choose to go to Canada.
Yeah, and the I-140 remains valid, so
Yes.
if it ever becomes current, you
can always come back.
and
And
consular
maybe
process.
if your kid becomes 21 and the kids are born here, they can still file the green card. That's another option there. But sitting down and watching these videos every week, I would choose to go to Canada.
Not that we don't appreciate you watching our videos.
But
We just wish you didn't have to.
I'm speaking of if I were the person on the other side of it, watching the video. It's my life is at stake every time. Extension, amendment, denials. Every time I have to travel outside the country, there's a lot of uncertainties. I would choose to go to Canada. That's me. Anything else, Emily?
One last question here. This is just popped up from Adarsh on YouTube. His wife's H4 extension is pending, and she's going to travel instead and go for stamping. He wants to know if she needs to inform USCIS before she does anything. No. She can travel and get the visa stamped and come back and not even worry about that extension at this point.
Emily, that's only for extension, not if she has filed from F1 to H4, is that right?
Correct. Change
Not
of
if-
status is a problem.
Is a problem, okay.
All right, I think that's about it for today. Thank you for joining us. Please say go Astros for us so they can win tonight, and we'll see you next Tuesday.
Thank you very much for joining.